Welcome to my colleagues. I am Edward Mogul, and I am a past president of the Illinois Academy of Criminology, which organized this program. Program is co-sponsored by the University of Illinois College of Law and the Illinois State Bar Association. We are honored to introduce our main speaker, a remarkable individual. Ann Burke, as you know, is the Chief Justice of the Illinois Supreme Court.
Well, good afternoon, everyone, and thank you, Professor Mogul, for that very kind introduction. Many thanks to the Illinois State Bar Association and the Illinois Academy of Criminology for organizing today's program. It is truly my honor and pleasure to introduce today's speaker, Mr. John A. Lupton. John is the Executive Director of the Illinois Supreme Court Historic Preservation Commission and has been a dear friend of mine for many years and that of our Supreme Court. The topic of today's presentation is Abraham Lincoln's career and professionalism as a lawyer. Let me assure you that you could not have more knowledgeable speaker than John Lupton on this topic. John has devoted his life's work to the study of Lincoln and his writings, making him an authority on all matters regarding Abraham Lincoln. And I am confident that you will find John to be as engaging as he is knowledgeable. And so it gives me great pleasure to present to you Mr. John A. Lupton. John.
Thanks, Chief, for that very, very kind introduction. I appreciate that. And thank you to Professor Mogul for organizing this. So let's begin with just a general overview of Lincoln's law practice. There's several myths about Lincoln the lawyer, which are kind of pervasive when we talk about Lincoln the lawyer. And one is that he was just this country bumpkin lawyer who didn't know what was going on in a case, and he pretty much won cases by wowing juries with his homespun stories. And then the pendulum kind of swung the other way, and then scholars talked about him as the super lawyer. He was a super lawyer because he never lost a case because he knew the right side of the case to be on. He was smarter than everyone in the courtroom, despite his appearances not being that intelligent. So that's the myth of the super lawyer. And then we also have kind of some sub myths beyond that. And that's that he was a cause lawyer where he only represented widows and orphans and never charged anyone fees for his services. And then that pendulum kind of swung the other way, where Lincoln was this massive corporate lawyer where all he did is take railroad cases on behalf of future robber barons of the late 19th century. Now, the problem with all these myths is that there's actually a kernel of truth to all of them. There were some examples where Lincoln is only representing widows and orphans. There are some examples where Lincoln was representing railroads, even though we found he had about 150 cases involving the railroad. There was about 75 of them where he was representing the railroad and about 75 where he was representing against the railroad. So the problem with these myths is that these previous scholars or historians, they would take one kernel or one little tidbit of Lincoln's legal career and they would generalize that to the entirety of his legal career. So my argument, now that I've set up my straw man here, my argument is just to show that there was this evolutionary track to Abraham Lincoln the lawyer. And I think you can probably say that about all of your practices, is that, you know, you're probably a much different attorney now than you were 5 years ago, 10 years ago, 15 years ago, you know, even when you got your law license originally. So there's an evolution to everyone's practice. And the same thing is going on with Lincoln's law practice. So we'll just kind of go over a few little points about Lincoln's law practice. His legal education was actually it was not typical. Most attorneys, they would study under an established attorney, just kind of work as an apprentice for a few years before taking the bar, or excuse me, not the bar, but before taking the exam to become a lawyer. What Lincoln did, though, is he was encouraged to study the law by a fellow legislator, John Stuart. And so he borrowed Stuart's law books and just read those several times through. And when Lincoln believed he had enough knowledge to become a lawyer, then that's when he took his oral exam and became a lawyer. Law schools actually weren't a very good option for people, because the nearest one, at least from Illinois, was Lexington, Kentucky, and Cincinnati, Ohio. And that was, weeks trip for anyone to be able to do that. So after Lincoln got his license in 1836, he went into 3 successive legal partnerships. The first with John Stuart, who was his first mentor, the one who encouraged him to study the law. And Stuart actually wasn't that much of a mentor once they began their partnership, because in 1838, he was elected to the US Congress. So he left for Washington, basically leaving Lincoln to become a solo practitioner after, maybe only a year or so of practicing together. So Lincoln really was learning by himself and was not getting the legal career that he had hoped for. So in 1841, Stuart and Lincoln dissolved their partnership amicably, and Logan invited Lincoln to become a partner with him. And Stephen Logan was known as one of the best trial lawyers in the state. And Logan introduced Lincoln to, the importance of collecting fees, introduced him to a large Illinois Supreme Court practice and a large federal practice. So Logan was the true mentor that Lincoln needed to become established as a lawyer. So after 3 years of Logan and Lincoln practicing together, Lincoln invited William Herndon, who was an apprentice in the Logan-Lincoln law office, to become his partner. And they remained partners until Lincoln left for Washington in 1861. So Lincoln's practice was actually quite large, at least compared to his colleagues. Because he was a Whig in a Democratic state, he actually didn't advance politically as much as he would have liked. So he devoted most of his pre-presidential career to the law. So he had more than over 5,100 cases over a 25-year period. About half of those cases were in his home county of Sangamon. Because Lincoln lived in Springfield, he had a large practice before the Illinois Supreme Court, more than 400 cases that we've uncovered. And he had at least 300 cases in the federal court. There were probably a lot more, but the Chicago fire of 1871 destroyed a lot of the early federal court records in Illinois. Now, in Lincoln's time, there were no specializations. So there were no family law attorneys, there were no elder law attorneys, no bankruptcy attorneys. Basically, all the attorneys were general practice attorneys. And Lincoln was, of course, a consummate general practice attorney. The largest part of his practice involved debt collection. We've estimated about 2/3 to 3/4 of his entire caseload was just collecting debts. And this reflects the cash poor, gold and silver poor society of antebellum Illinois. Lincoln also had a number of other cases. He had over 100 divorce cases, fair number of slander cases, ejectment, injunction cases. So he had a very wide variety of cases in his career, but most of them were dealt with debt. Lincoln earned a pretty comfortable income as an attorney. He was earning on average $5, $10, $15, $25 per case. Lincoln didn't charge by the hour. He, like most modern attorneys do, he would charge by the case. Generally, he would take some money up front and then take a promissory note on the balance at the end. And if you want an idea of what $10 to $25 is now, you can basically multiply that by about $30. So if he's making $10 a case in his time, that's about $300 per case in our time. So he wasn't making a huge sum of money, but he did pretty well for himself. He also charged higher fees for cases that went before the Illinois Supreme Court because there was a lot more research work involved in that. And federal cases, which by statute had a higher threshold for bringing cases before the federal court. So he generally charged higher higher fees for federal cases. And here's just a couple of examples. Just wanted to show you, he didn't always take money. In this promissory note up here that Lincoln himself wrote, it's basically a promise to pay Abraham Lincoln $20 in good firewood, about 4 feet in length. So he did legal work for this James Gambrell for some firewood. And also, if you've ever been to the Lincoln home, you'll notice that there's a brick retaining wall that's in front of the house. That was also barter. He got that brick wall for representing another person in a lawsuit. And Lincoln won the case, I believe. But as payment, this gentleman put in this brick retaining wall at his house. Now, Lincoln, when he was arguing these cases, it actually gave him a rich exposure to the issues that everyday Americans or Illinoisans were facing. He was arguing issues of economic development, personal conflict, and it really gave him kind of a deep understanding of conflict resolution, just in these small courts in central Illinois. So, that really helped him as he's as he becomes president, and dealing with, again, unruly job seekers and politicians who were looking for jobs. So Lincoln had that experience with that 25 years of experience in dealing with people like that as a president, simply because of his exposure to important issues as a lawyer. Now, there was a kind of a symbiotic relationship between Lincoln's legal career and his political career. And the law was actually a stepping stone for a lot of politicians. Stephen Douglas is probably one of the better examples of that. As Douglas, not long after he was licensed to practice law, he became state's attorney. He moved into other political offices, Illinois Secretary of State, Justice on the Illinois Supreme Court. He was then elected to the U.S. Congress, then elected to the Senate, and ran for president a couple of times. And obviously, not every lawyer went to that path. That's what Lincoln wanted to do. But as I said, as a Whig in a Democratic state, Lincoln didn't have many opportunities for politics. But he did give a lot of speeches, supporting his political causes. But one example here, so here's the Eighth Circuit as it existed kind of during the height of Lincoln's legal career. One aspect here that shows politics did play a little bit of a part in what the circuit looks like. As I said, this was the Eighth Circuit, and both Judge David Davis, who was the circuit judge for the Eighth Circuit, and Lincoln both believed that the Eighth Circuit was too large and they wanted it reduced in size. So Lincoln, even though he wasn't a member of the General Assembly, he wrote the bill for the legislature that removed Shelby, Christian, Macon, Moultrie, Piatt, and Edgar counties from the circuit. So they became a different circuit. So the Eighth Circuit was just this northern swath of counties. Now, interestingly and not surprisingly, Christian, Shelby, Moultrie, Macon, Piatt, and Edgar counties were all Democratic strongholds, whereas the northern swath was more of Whig strongholds and later Republican strongholds. So there was definitely a political interest of where Lincoln wanted to go in his circuit writing practice. Now, the other thing that really helped Lincoln out as an orator and as a president is that he was really able to develop his writing and speaking skills as a lawyer. He was already kind of a naturally gifted speaker, but becoming a lawyer and being able to focus his thoughts and his arguments, I think made him just even that much of a better writer and a better speaker. He was always known for telling great stories, which he wove into his legal cases sometimes. I've read before that Abraham Lincoln, the president, could not have written the Gettysburg Address had he not been Abraham Lincoln, the lawyer. And I believe that to be true. I think his legal career really gave him the skills to improve upon his homespun stories and really be able to get points across quickly and easily. Lincoln also devoted quite a bit of his arguments to humor in the courtroom. there was actually a newspaper article from the late 1850s of someone who had served on a jury who was also a newspaper editor, and he wrote an editorial afterwards saying that Lincoln uses humor in the courtroom, sometimes disrupts the court, but everyone always gets a good laugh out of his stories. And probably one of the better stories about his humor in the courtroom is this is the old Christian County courthouse. And when Lincoln was practicing law, it used to sit up on cinder blocks, so it was open underneath. And during an argument one time, Lincoln was making before the jury, some pigs started to roost underneath the courthouse, and they were making a lot of noise. So Lincoln, in the middle of his argument, stopped what he was talking about, and he made a motion to the judge for a writ of quietus to silence the pigs who were making so much noise. So Taylorville, which is where Christian County is, county seat of, put up a statue about 20 years ago, I would say 15, 20 years ago, of Abraham Lincoln and a pig. And as far as I know, it's the only statue of Lincoln with a pig, but it commemorates this case that we don't even know what the name of it is. It was just a story that has been handed down, but it certainly sounds like Lincoln. So that more or less concludes the first part of my presentation. Ed, have any questions popped in since I have been speaking?
There's a question. You mainly talked about Lincoln's litigation work. What percentage of his legal work did not involve litigation, like writing wills, deeds, or just giving advice? Can you speak to that? Is there any way to evaluate that?
Yeah, in addition to tracking down all of his legal cases, we also tried to track down what we called his office practice. So as you said, writing deeds, writing wills, and we found almost 600 instances of him doing this office practice type work where he's giving advice to people. So we probably think that is a much larger number because Lincoln was not the greatest bookkeeper of what he was doing as a lawyer. So, I'm sure there were many instances of someone just coming into his office, asking for some quick legal advice, paying $1 or $2 and going on their way. So unfortunately, we don't know how large his office practice was, but we know it was fairly substantial. Again, so if we're talking 5,100 cases that we know of, 600 office practice that we know of. So I can't do the math in my head that quick, but it was a fairly substantial part of his legal career.
Okay, we have another question. What was the difference in practice between a circuit riding lawyer and those who did not travel? Did they have something like a solicitor and barrister type division as in the English courts? That is, people who didn't litigate or try cases in court.
Most attorneys actually were litigators. Well, actually, they did everything. They were litigators and office practice attorneys. But there were some attorneys who didn't ride circuit. Actually, most attorneys, what they did, let me just go back to that slide real quick here. What most attorneys did, so if you lived in DeWitt County, for example, what an attorney would do was usually just travel to the counties that border that county. So a DeWitt County lawyer would have gone to Logan, McLean, Piatt, and Macon, and that would be about it. Lincoln and the state's attorney were one of the few, well, the state's attorney had to, but Lincoln was one of the few attorneys that basically traveled the entire circuit throughout his career. But by the time railroads came into fashion in the mid to late 50s, attorneys could actually, that kind of ended the whole practice of circuit riding. Attorneys could kind of go back and forth daily if they wanted to. In some cases. And when Robert Lincoln, Abraham Lincoln's son, was thinking about going into the law, there's a story that Abraham Lincoln told him, you'll probably know way more than I ever did as a lawyer, but you'll have half as much fun because of you won't be able to ride the circuit like I did.
All right, one final question on this section. Do you want to care to comment on Billy Herndon, the partner?
William Herndon. Herndon is kind of a controversial character in Lincoln historiography, mainly because after Abraham Lincoln died, Herndon went around and gathered up a lot of reminiscences from people who knew Lincoln, talked about his legal career, but where Herndon kind of got in trouble, I guess, with Lincoln files, is that he basically said, Anne Rutledge was Lincoln's true love. He and Mary had a horrible marriage. So things like that. Said that Lincoln was an atheist, more or less. And so Herndon's reputation has kind of been tarnished throughout the years. But we've actually found, a lot of recent scholarship has found that, many of Herndon's recollections are pretty accurate. So it's really just a matter of kind of sifting through some of Herndon's biases to get kind of the kernel of the truth of what he's trying to say. Also, I also read somewhere that, Herndon didn't understand jokes very well. And as a jokester, a lot of the things that Lincoln told Herndon took as literal, was as real. So I think some of it was just his inability to understand jokes. But Herndon is an important part in Lincoln studies because he gave us so much material to understand Lincoln's legal career, his life, his early life, much better than if Herndon had not have done any of that. I'm actually going to talk about Lincoln's notes for a law lecture now. And these were, we believe, well, there's a series of books that were published in the 1950s, the collected works of Abraham Lincoln. And these basically were all of Lincoln's writings and speeches. And the editor, Roy Basler, believed that this was written about 1850, Lincoln's notes for a law lecture. Some of the research that we did, we kind of estimated that it was going to be written about 1859. We found that Lincoln was invited to give a commencement address at a law school in Cleveland, Ohio. Now, we know he did not go to the law school to give the address because we kind of know where Lincoln was most times in the 1850s and 1860s. But these notes exist. So we're assuming, I think we've made an educated guess, that this is what he probably would have said had he gone to Cleveland to make his commencement address. So these notes are actually, it's a wonderful insight into how Lincoln viewed the practice of law and how to be a good lawyer in 1859. And I think there's even some nuggets there that, would be useful for attorneys today. So he starts out by saying, I am not an accomplished lawyer. I find quite as much material for a lecture in the points where I failed than in those points where I've been moderately successful. And I really like the way he opens that because he's basically saying that he's learned more from his mistakes than he has from his successes. So he's recognized, one, that, he's probably made a lot of mistakes as an attorney, but that he's learned from them, which is really kind of the point of making mistakes. So he kind of covers 5 different topics, which I'll go through individually. But, he talks about diligence. He talks about public speaking. He's got a section on discouraging litigation, not stirring up litigation, and then a section on fees. And also, I've provided the notes for a law lecture in your materials, not only the original pencil-written copy that he wrote, which is now at the Library of Congress, but also a transcribed copy. So just a really nice thing to be able to read over every once in a while. So again, I'll go through these points kind of one by one. So regarding diligence, Lincoln starts out by saying, leave nothing for tomorrow, which can be done today. And of course, that's kind of just good general advice, not necessarily for attorneys, but for everyone. But he's basically saying, don't let your correspondence fall behind. If you've got, if you're bringing a suit, if you've got all the facts, write your information down at once. Basically, just do all of your homework before you proceed further. And Lincoln more or less kind of took this to heart. There are actually quite a bit of examples of, Lincoln necessarily wasn't the greatest correspondence, let me say. And his office was actually, the Lincoln Herndon Law Office was really quite famous for being quite a mess. If you've ever been through the Abraham Lincoln Presidential Museum, there's a section there in the first journey of Lincoln's law office, and the kids are ransacking the place, but there's just piles of documents everywhere. And that's actually based on an accurate recollection of what his law office looked like. And there was one stack of papers that was in his desk that said, "When you can't find it anywhere else, look into this." So basically, this was Lincoln's miscellaneous file. If he was trying to find a particular document and couldn't find it anywhere in his office, he would go to this particular pile of documents in his desk. We also know that Lincoln used his hat as a filing cabinet, basically, or even a briefcase. And this is where he stored a lot of his letters, his checkbook. If he had an idea, he would jot it down on a piece of paper and put that into his hat. But sometimes this hat caused problems, especially this one example regarding correspondence, where he says in his notes for a law lecture, "Don't let your correspondence fall behind." Well, in one example, Lincoln received a letter from an attorney who wanted him to look up some information in the Sangamon County deeds. And Lincoln didn't answer for about 3 months. So he finally responds to this attorney. And so Lincoln writes, he said, "I apologize, for not sooner answering your letter. When I received your letter, I put it in my hat. And then the next day I bought a new hat. So your letter was lost sight of for quite a while." And then Lincoln goes on in the letter to do the research and answer his questions that he had asked, but much later than I'm sure what the attorney preferred. Also, while Lincoln became a pretty prominent attorney by the late 1850s, he started to receive a number of letters from potential lawyers who wanted to know about the best ways to become a lawyer. So Lincoln would write back to a lot of these people, basically saying that, I'm out of the office so much, but my partner Herndon is the one who kind of handles the apprenticeships. So you'll need to deal with him. But what Lincoln said in this particular letter to John Brockman, this was written in late 1860, in September of 1860. Brockman writes, wanting to know the best mode of obtaining a thorough knowledge of the law. And Lincoln said it's very simple, though laborious and tedious. It's to get the books, read them, study them carefully, begin with Blackstone's commentaries, and then read Chitty's pleadings, Greenleaf's evidence, Story's equity in succession. And then he concludes by saying, "Work, work, work is the main thing," which is just a great summary of, again, what you need to do to succeed in any occupation, not just being an attorney. The second part of his notes for law lecture dealt with public speaking. And what Lincoln says is that extemporaneous speaking should be practiced and cultivated. It's the lawyer's avenue to the public. So basically, if you're not a good speech maker, people might not even come to you, for business. But he was also arguing the opposite side of that. He said that there's no more fatal error to young lawyers than relying too much on speech making. So if anyone basically stop doing the drudgery of the law, stop doing the work, then your case is going to be a failure even before you get going on it. And one example of this is a conversation that he was having with his law partner, William Herndon, one time. Herndon said that Lincoln wanted to be understood by the common people. And he said to Herndon one time, he said, "Billy, don't shoot too high. Shoot down low and the common people will understand you. They are the ones which you wish to reach. At least they are the ones whom you ought to reach. The educated ones will understand you anyhow. And if you shoot too high, your bullets will go over the heads of the mass and hit only those who need no hitting." So basically this, kind of supports one of these myths that I was talking about earlier about Lincoln being this, homespun, these homespun stories trying to connect with jurors. Yes, there's absolutely a lot of truth to that, that he probably spoke a little bit of a different way when speaking to juries in order to connect with that. And this reminiscence by Herndon certainly supports that aspect of his legal career. The third thing that Lincoln talks about in the Notes for Law lecture is compromise. And this is where Lincoln is basically telling people to discourage litigation, persuade your neighbors to compromise whenever you can. And then so pointing out how usually sometimes the winner in a case is not too often the loser, in terms of fees, expenses, and time. So Lincoln says, as a peacemaker, the lawyer has a superior opportunity of being a good man, and there will always be business enough. And this is a part of his career that Lincoln, I think, really took to heart this point. Lincoln was known to try to get the parties to compromise in cases. In many cases, we see this quite a bit. Here's a letter which he's representing this Abraham Bale, who's wanting to sue Virgil Hickox. And Lincoln is friends with both of these people. And Lincoln concludes the letter by saying, I hope you'll settle it. I think you can if you will, because I found Mr. Hickox to be a fair man in his dealings. If you settle, I will charge you nothing for what I've done, and thank you to boot. Then again, by settling, you'll get your money sooner and with much less trouble and expense, which is exactly what he said in his Notes for a Law lecture. Another example of Lincoln kind of affecting a compromise here, and this wasn't just Lincoln, actually this was pretty commonplace, but slander was a fairly prominent, or I shouldn't say prominent, but it was often enough slander cases in antebellum Illinois, and really probably all over the country. And slander, as you know, is when one person says something bad about another person, and so that person ends up suing. Now, with slander cases, interestingly, there's kind of a gender difference among slander cases. Most men sued in slander because they were accused of lying or being a cheat or stealing, things like that. Most women sued in slander because they were accused of sexual improprieties. But the point of a slander case wasn't so much to gain a monetary award, but it was to reestablish your standing in the community. So it was all about reputation. So in a typical slander suit, a plaintiff would sue and request, say, maybe $1,000 in damages. The jury would find for the plaintiff and award $1,000 in damages, which is a significant amount of money back then. And what would almost always happen is that the plaintiff would remit, say, $925 of the damages, reserving $75 for the court fees and for the lawyer's fees. So Lincoln was known to kind of spearhead a lot of these compromises within the courtroom, particularly in slander, but not just in slander cases, but in a lot of debt cases and a number of other types of cases. So this was a part where Lincoln was known to be, to get his clients to compromise. And again, this is part of the Notes for a Law lecture that he followed very, very closely. So the fourth point that he brings up in the Notes for a Law lecture is not to stir up litigation, so which is a little bit different than discouraging litigation. So Lincoln says that a worse man can scarcely be found than one who does this. Who can be more nearly a fiend than he who habitually overhauls the register of deeds in search of defects in titles, just to put money in his pocket? A moral tone ought to be infused into the profession, which should drive these types of men out of it. And again, this was, Lincoln kind of took this to heart too. There's a couple of examples where he would get pretty riled up over cases. There was one case, this isn't necessarily about stirring up litigation, but it's how Lincoln can really get excited over a particular case. There was a case in the 1840s where a Revolutionary War widow brought a case against the pension agent who helped her get a pension, but he charged her an exorbitant fee. So the Revolutionary War widow goes to Lincoln, and Lincoln argues the case for him. And Herndon portrays this picture of Lincoln just angry and yelling, talking about the heroes of Valley Forge and, the importance of the revolution to our country. And so he's just angry about this case. Herndon says he's never seen him so angry. And Lincoln ends up winning the case for his client, the Revolutionary War widow. But what happens is that basically the pension agent's fee is reduced to a more reasonable figure. So Herndon says that the pension agent lost everything, but he didn't. We found the case and he actually got some money, probably what Lincoln thought he really deserved in the case. But another case or another example of not stirring up litigation is, again, this is a Herndon recollection. And so a gentleman came into the Lincoln Herndon law office and told Lincoln his story. So after the would-be client stated his facts in the case, Mr. Lincoln replied, "Yes, there is no reasonable doubt that I can gain this case for you. I can set a whole neighborhood at loggerheads. I can distress a widow mother and her 6 fatherless children and thereby get for you $600, which you seem to maybe have a legal claim to. But which appears to me, this woman and her children also have a rightful claim to it. You must remember that some things that are legally right are not morally right. I shall not take your case, but I will give you a little advice for which I will charge you nothing. You seem to be a sprightly, energetic man. I would advise you to try your hand at making $600 in some other way." So again, this supports perfectly this idea that Lincoln did not like stirring up litigation when it was not necessary. So the last point in the notes for a law lecture that Lincoln brought up is the matter of fees. And again, this is something, Lincoln, there's this myth, this reputation that Lincoln was always careless with his fees, not charging clients fees. And, there are examples of him, there's a letter that he received from someone, or excuse me, a letter that he sent to a client of his, and he sends $10, and Lincoln basically says, "You must find me a high-priced man. I didn't charge you this much. I thank you for the case. We won. Here's $10 back because I think you were overpaying me." So there was, some honesty in what Lincoln thought he believed he should be paid, but he still believed he should be paid. And again, this was something that Stephen Logan kind of taught him quite well when Lincoln and Logan practiced together. So Lincoln says the matter of fees is important, and you shouldn't charge exorbitant fees. You should actually take some money up front rather than taking the whole thing up front, because then you'll become disinterested in the case. And just to give you some more examples of Lincoln's interest in fees, here's a letter that Lincoln is writing to Thomas Howland. And Howland was suing the railroad, and he was supposed to send Lincoln a $100 retainer. And as Lincoln says in his letter, as you seem to think probable, the draft or the check that you drew is back upon us. So basically, Howland's check bounced. So Lincoln says, don't let it come upon us again, or we might be provoked to dismiss your suit. So Lincoln said, "I need $100 retainer. You bounced your check. I'm not going to work on this unless you pay us our money." So he believed he deserved to be paid for his services. And also there's examples of Lincoln suing clients to recover fees. Generally what would happen is that after a case was over, Lincoln generally took a promissory note because most people didn't either have the cash or the gold or silver specie to be able to pay him. So Lincoln would take a promissory note, and after the 6-month due date, if it didn't come due, Lincoln would sometimes sue that client in order to recover the money, which he was able to win. He also, filed claims against estates to receive money. And this case here that I'm showing, Shelby County Courthouse, what happened there is he was actually representing the great nephew of Davy Crockett, who was charged with a murder. And so Lincoln represented, his name was John Crockett. He represents John Crockett in this case, and he's found guilty of a lesser charge of manslaughter, sentenced to the penitentiary. But then Lincoln and John Crockett's father, whose name is Elliot, they go on this effort to get John Crockett pardoned because he probably had some sort of a mental illness, according to the pardon records. So they're successful in getting him pardoned before he serves in the penitentiary, which was probably the best thing that could happen for him because of his mental illness. But at any rate, after all this is over, Elliot Crockett gives Lincoln a promissory note for $50 for all of his work, but Crockett dies before he's able to pay off the work or pay off the note. So Lincoln ends up filing a claim against the estate in order to get his $50. And plus interest, it ended up being like $62. So Lincoln basically filed a claim against the estate of Davy Crockett's nephew in order to get paid for his legal services. Probably the most famous example of Lincoln suing a client for fees is the McLean County tax case. And most of you are probably familiar with this case, so I won't go too deeply into it, but this is the case where the state had exempted the Illinois Central Railroad from paying state taxes, but there was no information about what to do about county taxes. And so McLean County, which is right here, decided to charge a county tax on the land that the Illinois Central Railroad had. As you can see, the Illinois Central goes all the way from Cairo. The main line goes all the way to Galena, and then the branch line goes from Centralia to Chicago. So this is a lot of land that the Illinois Central has in the state. So basically, having to pay taxes on this land that the state exempted it from would probably bankrupt the railroad. So the case goes to the Illinois Supreme Court. Lincoln wins on behalf of the railroad, so they don't have to pay these county taxes. And so he submits a bill to the Illinois Central Railroad for $5,000. And obviously this is a large sum back then because the Illinois Central Railroad said, whoa, we don't pay Western attorneys that kind of money. That's what we pay, Boston attorneys and Philadelphia attorneys and New York attorneys. We don't pay these Western attorneys that kind of money. So they refuse to pay. So Lincoln sues the Illinois Central Railroad, his client, in order to get that money. And he's got affidavits by attorneys, and actually even the judge in the circuit level case, David Davis, writes an affidavit basically saying, yeah, that's a fair fee. He saved the railroad literally millions of dollars. So a $5,000 fee seems actually pretty cheap. So Lincoln wins the case, and that's how he gets his $5,000, which from what we know is the largest amount he'd ever received in a case. And again, as I said earlier, if you take that 5,000 times basically 30 to 1 ratio, so you're talking about $150,000 fee for this case. So Lincoln concludes his, I really like the way he concludes this, the notes for a law lecture. He basically says, that there's this vague popular belief that lawyers are dishonest. I say vague because when we consider to what extent confidence and honors are conferred upon lawyers by the people, and I like that part because what Lincoln is saying is that we elect lawyers presidents, we elect lawyers to the General Assembly, we elect lawyers to the U.S. Congress. So we're basically putting lawyers in positions of authority. So that's why it appears improbable that this impression of dishonesty is vivid, according to Lincoln. Yet the expression is common, almost universal, that lawyers have this bad reputation. So Lincoln concludes by saying, let no young man choosing the law for a calling for a moment yield to this popular belief that lawyers are dishonest. So resolve to be honest at all events. And if in your own judgment you can't be an honest lawyer, resolve to be honest without being a lawyer. So again, it's just a wonderful way to conclude his notes for a law lecture. And Lincoln really, believed in the idea of honesty in the law practice. And the notes for a law lecture, I think, really summarize what he tried to do in his law practice as best as he could. Okay, so that concludes the second session here. So Ed, have we received any questions about Lincoln's notes for a law lecture while I've been talking?
Before we leave the issue of fees, do you have any idea of how much money Lincoln earned annually from his law practice?
Annually from his law practice? That's been estimated that he was probably earning early in his career, probably about, $2,000, $3,000, $4,000 a year. By the end of his legal career, he was probably earning $10,000, $12,000, $15,000 a year, which again, gave him an opportunity to afford a nice house in a nice neighborhood. So he did well. He didn't make as much money as other attorneys. So what Lincoln did not do that a lot of other attorneys did is that they got involved in land speculation. David Davis, for example, he owned like the better part of McLean County through land speculation. So most of his wealth came through his real estate holdings. And there's another attorney in DeWitt County, Clifton Moore, who pretty much owned most of the county, and because he was involved in land speculation as well. But Lincoln didn't do that. He was content to earn his living through the practice of law.
All right. Is there a current law firm in Springfield that is a descendant of Lincoln and Herndon?
Not of Lincoln and Herndon. However, Brown, Hay, and Stevens is a descendant of the Stewart and Lincoln law office. After Lincoln left the firm, Stewart ended up, I'm going to get the genealogy wrong, so I apologize if there are any Brown, Hay, and Stevens attorneys on this. But Stewart ended up serving with Benjamin Edwards, I think it was. And then they brought in Brown, and then Logan Hay came in later. And then, so that's the genesis of the Brown, Hay, and Stevens law firm, which traces its roots back to Lincoln and Stewart's law firm in the 1830s.
All right. One other question from the chat. The fragment concludes with consent to be a knave. Could you explain your understanding of that?
Well, a knave is, isn't that a, I'm having hold on just a second here. I mean, I have a definition in my brain, but yeah, knave is, like a deceitful fellow.
Mm-hmm.
So, basically, if he's saying that, if you're going to be a dishonest lawyer, then just go ahead and consent to be don't be a lawyer, choose some other profession, and then just go ahead and be the deceitful person that you want to be. So that's what Lincoln is basically saying, is that he doesn't want these types of people, knaves, deceitful people, to be in the practice of law, because the law should be an honorable profession, not populated by people who are just out to cause trouble.
Right. Actually, one more question on this. Did Lincoln ever argue any cases before the U.S. Supreme Court?
He did. We know of one case that he argued before the United States Supreme Court. And this is from the time he was in the legislature, in the U.S. Congress, where he served from 47 to 49. So in 1849, after the congressional session was done, there was a case of his that he had handled like in 1845 that finally made its way up to the U.S. Supreme Court. So Lincoln argued the case, and it was extremely complicated land, about when the statute of limitations begins and when it should have began or something like that. Lincoln ended up losing the case, and Roger Taney, I think, was the one who wrote the opinion in the case. Roger Taney obviously is well known for authoring the Dred Scott opinion, which kind of was one of the factors that led to the U.S. Civil War, which also led to Lincoln becoming president. So there's this long history between Taney and Lincoln that goes all the way back to 1849.
All right, we do have a note from one in the audience. Robert Stewart is an attorney at Brown Hayes. So that completes that.
Yes, excellent. And he's a descendant of John Todd Stewart. So
Yes.
I know Bob very well. Hello, Bob. So the last topic that I wanted to talk about with Lincoln's legal career is sort of his reverence that he had for the law and the legal profession. So Lincoln's family history actually goes all the way back to the early colonial periods, like to well into the 1600s. Lincoln wasn't aware of this, but he knew. I mean, he knew of his family history going back at least to his grandfather, great grandfather. That they were Pennsylvania Quakers, and so Lincoln sort of has this rich heritage for his colonial ancestry. So he knew his family had been in the colonies for a while. So this deep colonial ancestry gave him even greater pride in the country in which he was born, in which he resided, and of course he had extreme reverence for the two principal documents that ended up building this country, which is the Declaration of Independence of 1776 and the 1787 U.S. Constitution. Lincoln said that these two documents actually dovetailed really nicely together. He referred to the Declaration of Independence as an apple of gold, and the Constitution is the picture or the frame of silver, which is subsequently framed around it. So Lincoln is writing, and this is a note that he didn't publish anywhere. It's just a kind of a scrap of paper that was found. But he added that this picture was made not to conceal or destroy the apple, but to adorn and preserve it. So the picture was made for the apple, not the apple for the picture. So Lincoln concluded in this little notes that he jotted down that neither the picture nor the apple shall ever be bruised, blurred, or broken. So Lincoln, as I said, views the Declaration and Constitution as these perfectly paired documents that guide this country. So we have an idea of the reverence he had for the document that created this country and the document that provided its framework of laws. So, did what he did in his life that support this? And the answer is a clear yes. And this goes all the way back to Lincoln, the state legislator. So really, for a lot of people, a lot of historians, Lincoln's time as a state legislator in Vandalia is kind of overlooked as an important building block in his legal career. Scholars really look at this as his first foray into politics, which of course is true, but there's really more there. So Lincoln spent 8 years in the state legislature from 1834 to 1842. 6 of those were in Vandalia and 2 of those were in Springfield. And this was a huge educational experience for Lincoln. So this was really kind of his first, in a sense, legal training. As we know, Lincoln had limited schooling. He himself said that he only had about a total of 6 months of formal classroom education. But he did have this innate intelligence and a real curiosity to learn. So he mostly educated himself by reading the Bible, short stories, and even law books. So in the General Assembly, Lincoln was able to learn, correct draftsmanship of legal documents, bills. So the importance of words and choosing them carefully. And he also began to hone his speech-making skills to full effectiveness. And this supports what I was saying earlier about Lincoln's writing and speaking abilities. So here as a legislator, this is where he was really first kind of experiencing dispute resolution as a Whig when he was working with fellow Democratic legislators on internal improvements and even other bills in the legislature. So early in his career, he gave a speech to the Young Men's Lyceum in Springfield. And this was right after, he gave this speech right after Lovejoy was killed by a mob in Alton. Elijah Lovejoy was killed by a mob in Alton. And so he's kind of talking about mob mentality quite a bit in this speech. And so he's arguing that this mob mentality can destroy the very fabric of our country. And so his solution was, and I'm going to quote from his speech here, to let every American, every lover of liberty, every well-wisher to his posterity swear by the blood of the Revolution, never to violate in the least particular the laws of the country, and never to tolerate their violation by others, As the patriots of 1776 did to support the Declaration of Independence, so too the support of the Constitution and laws. Let every American pledge his life, his property, and his sacred honor. Let every man remember that to violate the law is to trample on the blood of his father and to tear the character of his own and his children's liberty. Let reverence for the laws be breathed by every American mother to the lisping babe that prattles on her lap. Let it be taught in schools, in seminaries, and in colleges. Let it be written in primers, spelling books, and in almanacs. Let it be preached from the pulpit, proclaimed in legislative halls, and enforced in courts of justice. In short, let it become the political religion of the nation. So Lincoln said this really early in his career. You know, again, it's a great speech that shows his reverence for the Constitution and for the Declaration of Independence, but even for the laws that we must abide by to become effective citizens in this country and in this state. But it was a message that he really carried throughout his professional life as an attorney and eventually as president of the United States. So if Lincoln learned reverence for the laws as a legislator, he solidified that reverence as a lawyer. As we said, Lincoln practiced law for nearly 25 years, really uninterrupted except for that 2-year term in Congress in the late 40s. So the law was his livelihood. It allowed him to pay off his old New Salem debts, and marry an upper class woman and live in a nice Springfield home. And Lincoln, gained this reputation as an excellent lawyer by being a lawyer's lawyer. So he was helping lawyers who needed assistance with their cases. And so the best example of this is really at the Illinois Supreme Court. So during the 40s, when the Supreme Court was only in Springfield, lawyers who lived in Galena or Shawneetown or Chicago, they did not want to make the 3, 4, 5, 6-day journey from their hometowns to Springfield to argue the case before the Supreme Court. Excuse me. So they would hire Springfield attorneys to argue their cases. And Abraham Lincoln was one of the more sought after attorneys to argue cases before the Illinois Supreme Court, which is why he had such a large caseload, again, over 400 cases. So there at the Supreme Court is when Lincoln really had time to prepare for a case. And he was an extremely formidable opponent when he could immerse himself in the case. And his colleagues would say that he was able to summarize his opponent's argument better than the opponent himself. And this gave him a really good advantage, obviously. So unlike other attorneys, Lincoln was really kind of giving both sides of a legal issue a fair shake. And it shows his commitment to the law to resolve issues, whether they be personal issues, or other issues that found their way into the court system. One of the more interesting examples of this is, how Lincoln valued his own reputation as a lawyer. So in the 1850s, Mary Lincoln's father had a partnership with this Alderman Hemingway. And Robert Todd, when he was still alive, told Lincoln that there were 2 unpaid accounts in Central Illinois, and whatever money Lincoln could get from them, he could just keep. So after Mary's father died in 1849, Alderman Hemingway, these 2 former business partners, accused Lincoln of withholding nearly $500 in money from them, essentially charging Lincoln with fraud. So Lincoln took this really personally, knowing that a person's reputation is his lifeblood in the community. So Lincoln wrote to his attorney in Lexington saying, "I find it difficult to suppress my indignation towards those who have got up this claim against me." Lincoln ended up saying that he collected $50 from one account, but nothing from the other one. But he ended up settling those accounts with Robert Todd's estate. So he was angry that he was being accused of theft. So just as abruptly as this charge came about, the 2 business partners ended up dropping the matter, and Lincoln was relieved. And these charges caused him considerable worry. And the tone of Lincoln's letters, and there's 3 or 4 of them, it reveals his determination to maintain his innocence and defend his reputation as an honest lawyer. So professional men like Lincoln, they sought to establish these reputations as hardworking individuals with honor and integrity. And this charge particularly threatened Lincoln's professional reputation, and he responded quickly to it. And again, it shows Lincoln's commitment to the rule of law, that he trusted the legal system to resolve this dispute on his behalf. and that people should abide by common sense and decency when dealing with other people. So when Lincoln became president, so he took all this information pre-presidency, he took it to the White House. And a lot of people thought that a country lawyer with no executive experience would be a disaster taking over the country during the secession crisis. But really, in one sense, there was no better experience that Lincoln brought to the table. He'd worked for a quarter of a century in the courthouses of Illinois dealing with these economic issues, these property issues, and personal conflict. So his time negotiating peace between these warring Central Illinoisans helped him immensely in preparing for the Civil War. Really, you could say no one understood conflict resolution better than he did. So as president, Lincoln saw secession as a legal matter. This was an issue that dealt with the rule of law. Was it legal for a state to leave the Union? The South's answer was that yes, the state can leave the Union because the states formed the Union. But Lincoln's view was that he saw the Union as an inviolable contract among the states, which again was begun by the Declaration of Independence and confirmed by the Constitution. So Lincoln's role was to preserve this binding contract. And now there were some inconsistencies with Lincoln as president. For example, during the Civil War, the western counties of Virginia seceded from the state to become West Virginia. And Lincoln saw this as constitutional. And U.S. Supreme Court even confirmed it after Lincoln's death. But in Lincoln's eyes, it was okay for counties to secede from a state, but it wasn't okay for states to secede from the Union. Now, another major criticism of Lincoln as president was his suspension of the writ of habeas corpus. Habeas corpus is the law that we inherited from Great Britain that prevented unlawful arrests and detentions. Lincoln suspended the writ first in the Baltimore area and then nationwide by 1862. And this allowed for arrests without warrants and prison without trials. And a lot of peace Democrats and anti-administration Democrats were arrested for disloyal activities and imprisoned with no charges. Democrats charged that this was politically motivated, that it didn't help in the war effort. But Lincoln's famous response is that the president had the right to suspend the writ in cases of rebellion, and this was certainly a rebellion. Lincoln also argued that, must I shoot a simple-minded soldier boy who deserts, while I must not touch the hair of the wily agitator who induces him to desert? Now, after the Civil War ended, the U.S. Supreme Court confirmed that Lincoln had the right to suspend the writ of habeas corpus, but was strongly opposed to military trials of civilians. So courts were kind of fairly consistent in both in their belief that Lincoln overextended his presidential authority with arbitrary arrests and military trials. So, and it's really, this is kind of an age-old question that evokes, kind of strong sentiments on both sides. Was Lincoln correct in suspending the writ of habeas corpus? And, the correct answer is, really not clear. It certainly caused ill feelings toward the Lincoln administration, but it probably did help the war effort in places where the war was close. But it probably wasn't necessary to arbitrarily arrest citizens, hundreds, if not thousands of miles away from the battle lines. So this might be construed as a major deviation from Lincoln's consistent affection toward the rule of law, but it really isn't. Lincoln's thought was that, and I'm quoting here, the whole of laws which I was sworn to take care that they be faithfully executed were being resisted and failing to be executed in nearly 1/3 of the states. Are all the laws but one, meaning habeas corpus, to go unexecuted and the government itself go to pieces, lest that one be violated? So in Lincoln's mind, the end, which was saving the Union, justified the means, which is suspending the writ of habeas corpus. Or in other words, extraordinary times called for extraordinary measures, and Lincoln did that. So Lincoln's commitment to the rule of law was really a principal feature throughout his life and throughout his presidency. It began with a deep respect for the Declaration of Independence and Constitution that continued with the service in the General Assembly and Congress, prominent feature of his legal career and carried into the presidency. So throughout Lincoln's legal career, he practiced politics and law according to these common sense guidelines that reflected his professional ethic. His commitment to the rule of law and his honesty drew clients to him, and it developed his excellent reputation among colleagues and even in the political arena. So Lincoln's legal experience of dealing with angry farmers, deserted wives, and unpaid creditors helped him in dealing with angry generals, deserting soldiers, and wanting to be paid office seekers. So Lincoln took this knowledge, this professional ethic, this reverence for the laws from the prairies of Illinois to the executive mansion in Washington, D.C., where he would go to fight and win the greatest legal and constitutional problem in American history. So thank you very much. I appreciate you taking your time out of your busy day to learn more about Lincoln the lawyer, which is a subject of mine, which I'm very interested in and passionate about. So Ed, do we have any more questions?
Well, let's see. There is a comment, and that is, isn't there a searchable online database? The scholarship is voluminous, I can tell. Is there something that people, if they're interested, can look up themselves associated with the Abraham Lincoln Presidential Library?
Yes, there are several ones that they can look at. If you go to the Abraham Lincoln Association's website, you can access the collected works of Abraham Lincoln, which are freely available online. The Abraham Lincoln Presidential Library and Museum has it's a law practice of abrahamlincoln.org. And from there, you can look at basically the entirety of Lincoln's law practice. All 5,100 cases, if you wish to choose to do so, are there at the law practice of abrahamlincoln.org. So yes, you can go to those features there.
Thank you. We have a question. Is there any indication that Lincoln would have returned to the law post-presidency should he have survived?
Yes, actually, what Lincoln had hoped to do, he told William Herndon that, to leave the Lincoln and Herndon shingle up outside the door, and that, he'd hoped to come back to Springfield and practice as if nothing had ever happened regarding the presidency. That didn't happen, obviously. There's also been talk that he might have moved to Chicago to practice law up there. And especially if his son wasn't licensed until the late 1860s, 68 or 69, I believe. So that's something, it's possible that he might have brought his son into a legal career with him, but we don't know what his plans were. He also wanted to travel. He wanted to go to Jerusalem. He wanted to see the holy cities of Jerusalem. So those were some things that we know he wanted to do, but obviously wasn't able to.
I see. And I did want to comment, I hope this isn't too pedantic. I'm not accusing him of plagiarism, but that image of the golden apple and the silver filigree is mentioned in Maimonides' Guide for the Perplexed, which was written in Cairo in 1184. And the idea was that there is some kernel that's obscured, yet somehow still visible through a filigree surrounding it. And although I'm sure he was a literate fellow, I'm not sure he came across Maimonides, but that still is interesting that he felt such reverence for the books. I wonder, how would Lincoln have felt if he had been transported to 2021 and gone into a law library and seen there were no books? And it makes you wonder what is permanent about what he said and useful to us as attorneys, and how would he have reacted? I think what your very excellent summary has shown us is that he had a grasp of the big picture. He had some idea of the nobility of the law, and it was a passion for him that guided him in advising other lawyers who sought out his advice and so on, and informed the way he practiced. So there is an issue here, I think, that is almost philosophical about the nobility of the practice of the law. And there's a fellow who said the apple and the filigree comes from Proverbs. And certainly, this fellow says Lincoln was familiar with the Bible.
Right.
Yes, that's wonderful.
Mhm.
So, are there any other comments? This is your opportunity to address them to a real scholar in this area. I did want to, before we conclude, thank you, John, for your presentation. It was wonderful to listen to. I want to thank Justice Burke for honoring us with her participation. And I'd like to thank Jeannie Heaton and Tara Sanders, in particular from the Illinois State Bar Association, who handled all of these technical matters and made this such an easy experience for all of us. I wonder if there will be a broader interest in this beyond the legal profession. Maybe we'll think about having a program for the schools to have them see how Abraham Lincoln practiced law. So, are there any other comments anyone wants us to talk about?
I just wanted to ask John, this is Steve Beckett, the rule of law of Abraham Lincoln seems to be challenged by the fugitive slave cases, in which the lawyers defending the fugitive slaves are looking for loopholes or arguments to get their freedom or delay or do something else. And I just don't remember this. Did Lincoln ever take a position on the defense of those fugitive slave cases?
Lincoln generally avoided fugitive slave cases. We don't know if that was for political reasons or why, but there were a fair number of fugitive slave cases that came to Springfield, and Herndon actually handled a couple of those, but Lincoln didn't get involved with them. I mean, the only one, he was involved in a few, but the one famous one, of course, is where Lincoln was on the side of the slave owner, not the fugitive
Right.
slave, in Columbus County in the 1840s.
Yeah, but don't you find that the Lincoln's view opposing slavery is therefore, in some sense, opposing the law of the land?
Well, boy, that's a tough question, because he believed that slavery was constitutional where it existed. What he was opposed to, he was morally opposed to the idea of slavery, but he was opposed to the idea of the expansion of slavery politically. And that's what the Republican Party was formed, or that's what it was formed on. And Lincoln was elected president under that platform, to stop the expansion of slavery. Lincoln probably didn't have any interest in getting rid of slavery. He thought it would just die out on its own. So, and he even held on to colonization for a while before he kind of embraced emancipation in the 1860s. So we could probably spend another couple hours talking about that, Steve.
Right. Final comment from William and I, very affirming. It's good to be a lawyer. So that's where we are now. Thank you again, everybody. Next time. Bye-bye.